In respectful presence of our brothers and sisters across boundaries and faiths, let us all join in prayer and worship and gratitude and for guidance. Almighty and eternal God, we thank you for the gift of life and all its joys. We thank you for today, for all its challenges, in all its splendor. We thank you for the gift of one another. O God of infinite mercy and wisdom, only in unity with your will can all our toils have true meaning. Transform us into willing and able stewards of this world and its future. Bring us together to work with understanding and compassion. As we toil and grow weary, we pray for renewed strength and resolve. As we experience pain and sorrow, let us be reminded of untold good beyond. As we see pain and suffering, let us be instruments of your peace and extensions of your loving and healing hands. As we gather here today, bless us all that our collective knowledge be tempered and guided by your wisdom. Grant us clarity of vision to see the common good amidst all distractions. Endow us with humility and purity of heart to transcend all differences and reservations. When we leave this gathering, let us be the change we seek. As we endeavor to practice what we learn, let us be the good we want to see in others. As we work for our learners and their future, let it be that your will be done. In solemn silence, let us conclude with our own personal prayer.
Mga kababayan, ang pambansang awit ng Pilipinas.
Okay,
Mga
good.
kababayan,
Oh,
ang pambansang awit ng Pilipinas.
okay, sorry. Good morning to everybody watching our stream over on Facebook Live. I'm Regina and I am your host for Pals Free Week with frequently asked topics on the bar subjects. Welcome to our dear deans, speaker, professors, and bar takers tuning into our stream. Day 3 of the 2022 bar examination is already tomorrow, and we're all closer to becoming lawyers, so kapit lang. This is the 5th lecture from this series, and we're very excited as we continue to help our barristers prepare for their exams. For this morning, we will answer the FAQs on civil law to accompany what we already know. The past 3-week frequently asked topics on the Bar Subjects Lecture Series is brought to you by the Philippine Association of Law Schools in collaboration with Rex Bookstore and Rex Educampion. To know more about our event partners, let's all watch this video. Okay, we seem to be having technical difficulties. So, okay, we'll get back to Rex in a bit. So thank you again to Rex Bookstore and Rex Educampion for collaborating with us on this event. Okay, na po ba? Okay, here.
Ako si Romel, Proud Print Production Manager.
Ako si Giselle, proud pre-press artist.
Ako si Dom, proud ako na production supervisor.
Ako si Ann, proud editor.
Ako si Jonah, proud researcher.
Ako si Chris, proud author.
Ako si Roxanne, proud artist.
Ako si Nelly, proud sales assistant.
Proud ako na nagagamit ko ang aking talento para matulungan ang isang estudyante, guro o magulang na magkaroon ng imahen ng isang aralin na kanilang gusto o kailangan matutunan.
Proud ako kasi sa umpisa pa lang ng book development, kasama na ako. Working with the authors, so sa journey ng libro hanggang sa magamit na ito ng mga learners. Para makatulong to make them whole and responsible Filipinos. It's a good feeling.
Maaaring sa iba ay tagasakay ka lang naman ng papel sa makina. Ngunit, ang kada papel na yon ay siyang bumubuo ng isang libro na nakatutulong sa isang bata o sa isang tao upang matuto at umunlad. Proud ako na maging bahagi ng prosesong ito.
Proud ako na yung pinag-aralan ko, yung pinagsikapan ko, yung pinuhunan ko ng bawat oras, pagod at puyat. Ngayon buo na, ngayon isa ng libro. I am full of hope na ang bawat makabasa nito, matuto, makinabang at makibahagi.
Teacher ang nanay ko. Proud akong gumising sa bawat araw na alam kong may ginagawa ko ang makakatulong sa kanya sa araw-araw niyang pagtatrabaho.
Proud ako maging print production group manager dito sa Rex Printing dahil ang ginagawa namin libro ay nagbibigay ng kaalaman sa mga kabataan. At isa pa, siyempre nagbibigay financial support sa aking pamilya. Kaya proud ako.
Yung anak ko, nakita ko na hawak niya yung isang libro na inimprenta natin. Nakwento daw niya sa mga kaklase niya na dito ako nagtatrabaho sa Rex. Nabanggit din niya yung mga pagbabasa at pag-e-edit na ginagawa ko sa mga produkto natin para masiguradong maganda at maayos ang kalalabasan ng mga produkto. Gabi na nga daw ako umuwi kung minsan para lang matapos yung libro. Para sa pamilya, para sa bata, konting sakripisyo, kayang-kaya.
Nung nag-aaral ako, marami rin kaming libro. Lalo na yung nag-aaral ako sa law. Never akong gumamit ng photocopy or illegal downloads. Gusto ko kasi yung pakiramdam na may hinahawakan ka ng totoong libro. And those books helped me become who I am today. So proud ako kasi alam kong may isang tao rin ako matulungan sa pagsusulat nito.
Proud ako kasi bawat customer na nakakaharap po namin dito sa branch, laging may kwento. Ang anak ko, naku, ayun, pumasa na sa kanyang exam. Salamat sa inyong libro. O di kaya may lalapit na, buti na lang, may kopya kami ng ganitong title. Hulog kami ng langit. Ang makita ng ganitong mga ngiti sa mga customers sa tuwing nakakuha sila ng kopya ng title ng libro, nakakagaan din ng loob. Kasi parang naging parte na rin tayo ng buhay nila at ng journey nila.
Ako si Tony Morano, proud customer of Rex. Sa lahat ng nagbigay ng oras, atensyon, expertise, sa lahat na rin na nagpagod at nagpuyat para sa mga libro ngayon ay lifeline ko. Proud book owner ako at proud ako sa inyo.
It takes a whole community to raise a whole child. and the whole community to create learning solutions to help every learner. Sa lahat ng edukampiyon sa likod ng bawat papel ng ating mga libro, proud kami sa inyo.
Ako si Romel, Proud Print Production Manager.
Ako si
Stressed out? Wishing for new ways to learn and master codal provisions? Codify makes it easy with just a few taps. You can customize and select the tracks to memorize or study further. With Codify's Playlist Manager, choose from the subjects and create your own playlist. Imagine your own law track. Experience studying the law anytime, anywhere. Fortify learning with Codify. Meet your new learning buddy. Download Codify now. Achieve your learning goals, one track at a time. Listen and learn with Codify. Get the app today. Your first 7 days are on us.
Okay, thank you so much, Rex Foxler and Yex Educampion, for collaborating with us on this event. Today's program aims to determine the most frequently asked questions for civil law. These FAQs will be determined and answered by a distinguished guest this morning, and they have prepared a presentation to help the bar takers as they take the exam of their life. To introduce our speaker, Attorney Myra Angie Batungbacal is a counsel, an arbitrator, a mediator, and an educator. She finished Bachelor of Laws from the University of the Philippines and her pre-law course, AB History, also from the same university, where she graduated valedictorian of the College of Social Sciences and Philosophy, UP Diliman, as magna cum laude. She is currently pursuing Master of Laws in the University of the Philippines while serving as a partner in the Batungbacal Law Office. Currently, she is the Senior Vice President of the National Center for Mediation for Policy Directions and Development, a member of the Board of Trustees of the Philippine Institute of Construction Arbitrators and Mediators, a legal consultant of the Conflict Resolution Group, a member of the International Organization Chartered Institute of Arbitrators, and various other ADR organizations campaigning for the use of ADR in the business sector, public sector, and local communities. She is a faculty member of the San Beda College of Alabang School of Law, teaching ADR and civil law subjects, University of Asia and the Pacific, where she teaches civil law review, and the Lyceum of the Philippines College of Law, where she teaches commercial law review and ADR. Recently, she has also joined the roster faculty in Adamson University, where she teaches ADR law and civil law subjects. And she is likewise a mandatory continuing legal education lecturer, bar reviewer, lecturer, and mentor and coach for bar candidates. So without further ado, let's all welcome this morning's lecturer, Attorney Angie Batungbacal.
Hello, good afternoon. Thank you, Ms. Ridge, for that wonderful introduction, generous introduction. So I shall be speaking to you about obligations and contracts and wills and succession this afternoon. It is now, this morning rather. So let's get on with it. No, I know that you have already taken the 2 bar exams in political law and commercial law and criminal law last Wednesday and last Sunday. And I know that you are prepared already for tomorrow's bar exam is in civil law. No, so my first tip to you is this: go there to the bar site with courageous hearts and believe that you can do it. If others have done it before, there is no reason why you cannot nail these examinations, these bar exams. So have a courageous heart, set aside all fears, because God is bigger than all our anxieties and our fears. Okay, so please keep that in mind. So let's now get on with business and let's do obligations and contracts. And I would want to share the screen with you, and I am allowed to do so. Okay, so you can see these, Okay, the topics for obligations and contracts are these: definition, elements of an obligation, different kinds of prestations, classification of obligations, sources of obligations, nature and effect of obligations, kind of civil obligations, joint and solidary obligations, extinguishment of obligations. Now, what are the trending topics in obligations? I'll give you these, no? So elements of obligations, you have to know this, the definition of obligations. We are also big on sources of obligations, joint and solidary obligations, and extinguishment of obligations. So let's start with that, with the definition of obligations. What is an obligation? Article 1156, can everyone see these? Ms. Reg, can the public see the PowerPoint presentation?
Yes, po. Yes, po.
Okay, so it says here, Article 1156, an obligation is a juridical necessity to give, to do, or not to do. There are basically three obligations, no? To give, to do, or not to do. So our obligations can be categorized in these three categories, no? Example, if I owe someone an amount of money, what am I supposed to do? No, my obligation is to pay or to give that money back. So that prestation or obligation is to give. If I were, for instance, employed, no, to give a service, to paint, for instance, a portrait, what is the prestation involved? What is the obligation involved? It is to do, to make that painting, right? What is an obligation not to do? No? For instance, I am not to be a nuisance, or I should not engage in any activity that will prove to be a nuisance to the community. So that obligation is not to do. So obligations can be categorized into these three. Number one, to give. Number two, to do. And number three, not to do. Now, what do we mean by juridical necessity? Has it ever occurred to you? What does that mean, juridical necessity? It is very simple. It just means non-compliance with this obligation results to juridical or legal sanctions. Example, if Ms. Regina Suarez, for instance, owes me 10 million and she does not comply with her obligation to give that money back to me, are there legal sanctions? Will I have a cause of action against her? And the answer is yes. So if we, now that we read Article 1156, an obligation is a juridical necessity to give, to do, or not to do, we know that if we do not comply with our obligation, there can be legal sanctions. Okay, a person who is aggrieved because of the non-compliance of an obligation by another party can seek legal remedy. Okay, so we're clear about that. So an obligation is a juridical relation whereby a person called the creditor may demand from another called the debtor the observance of a determinative conduct, the giving, doing, or not doing, and in case of breach of that obligation may demand satisfaction from the assets of the latter. What are the elements of obligations? We know these already. There is the creditor and the debtor. There is an object or prestation that is the obligation. So remember, keep in mind that prestation means obligation, and the obligation can either be to give, to do, or not to do. Then we have that efficient cause or the vinculum. Another phrase that we use is source of obligation. Okay. So, just to give you an example, no? Ann Curtis is to star in a film entitled Mahirap ang Maging Bar Candidate, to be produced by Viva Films. She signs a contract with Viva Films. Now, here, Ann is the debtor, no? And Viva Films is the creditor. Now, what is the prestation here? What is the obligation? The obligation is for Ann to act in said film. What is the vinculum of that obligation? What is the source of that obligation? The source of the obligation is contracts. Okay? Classification of obligations, you know, civil. This is sanctioned by law. Okay? It can be natural or a moral obligation based on conscience or moral compassion. For instance, no, duty to hear mass, duty to help neighbor, duty to help a friend in debt. Now, insofar as subject matter is concerned, we have real obligation. Wala pong fake obligation. Huh? But when we say real obligation, there is a need to deliver a thing. So real obligation contemplates delivery of a thing. And then a personal obligation may be to do something or not to do something. For instance, what are obligations that are to do? To give support to children, the employee to render services, a lessee to pay the rental fee, okay, a seller to transfer ownership and deliver the purchased item. Okay. So let's look at this. Now, insofar as viewpoint is concerned, it may be unilateral when only one party is bound, and bilateral when two parties are reciprocally bound. For instance, in case of a sale of Mitsubishi Montero Sports, right, what are the obligations involved here? The seller takes it upon himself or herself to deliver said property and convey ownership to the buyer. The buyer, on the other hand, undertakes to pay the seller the purchase amount. Now, insofar as lease of a condominium unit is concerned, the lessor undertakes to, of course, let the lessee possess that condominium unit or take possession of the condominium unit while the lease contract is in place or existing, right? Whereas the lessee, on the other hand, should be able to pay the rental fees as agreed upon and as stated in the contract of lease. Now, insofar as employment contract is concerned, of course, the employer will have to pay the employee and the employee will have to render services. Okay, now, I want you to take a look at this, a close look at the sources of obligations, because this is one of the trending topics in the bar exams. What are the sources of obligations? Please keep this in mind. One is a law. Second, contracts. Third, quasi-contracts. Fourth, delicts or acts or omissions punished by law. And 5 is quasi-delicts. So let me share the screen here and discuss the first 3 sources of obligations. Okay, so for instance, no, why do parents support their children? What is the source of that obligation? The obligation is the law, where parents have to support their minor children, send them to school, feed them, okay, take care of them, provide them, address their medical needs, for instance. No? So these obligations are based on law. Why do we not drink and drive? The law provides that we do not do that. We do not drink and we do not drive. Okay? Or we do not drive while intoxicated. We do not drive while texting. The law states that. What else? No? Say, for instance, we pay our taxes. Where does that obligation come from? What is the source of that obligation? The source is the law. That is why we all learn taxation laws, right? Tax laws. Okay, so these are some of the obligations based on law. And you know all this, right? Okay, now the second source of obligation are contracts. Why? Contracts, the terms and conditions of the contracts are the laws between the parties. Can parties stipulate on, can make necessary stipulations in the contract? Yes. Do we allow the parties to do that? The answer is yes, so long as the terms and conditions of the contract are not contrary to law, public morals, or public order. Say, for instance, a corporation. Can a corporation give its employees 14th month pay on top of the 13th month pay, which is mandatory? 15th month pay, 16th month pay, 17th month pay? Yes, of course. Can parties agree? No? Can the collective bargaining agreement state that employees are given 14th, 15th, 16th, 17th month pay? Yes, of course. It is not contrary to law. That term, that provision of their contract is not contrary to law. It does not violate the minimum standards, right, required by law. So that is all right. It is not, it is allowed by law. So the terms and conditions of the contract are allowed so long as they do not violate any law or they are not contrary to public policy and public order. Pwede yun. That is allowed. If the employer is generous, can he be more generous? Yes. That is all right. No? For instance, in case of sale, can the parties agree that there be several installments? The answer also is yes. Can the parties agree on a down payment? Yes. What about 5 installments? Yes, also. So long as both parties agree. And this does not, the terms and conditions of the contract do not violate any law, then that is allowed. So contracts. Again, by way of a drill, what are the obligations? Sources of obligations. Number 1, law. Number 2, contracts. And number 3, we have now quasi-contracts. Now, what are quasi-contracts? What come to mind when we think of quasi-contracts? We think of 2 things. Number 1, negosyorum gestio, and number 2, solutio indipiti. What is negosyorum gestio? Negosyorum gestio refers to an authorized management. So let me share the screen with you again, and then I shall explain. Okay, now, insofar as, quasi-contract as a source of obligation is concerned, let's look at this. A quasi-contract is that juridical relation resulting from a lawful, voluntary, and unilateral acts, and which has for its purpose the payment of indemnity to the end that no one shall be unjustly enriched or benefited at the expense of another. Okay, as I have mentioned earlier, we speak here of, under that, we speak of two things. Number one, negotiorum gestio, or unauthorized management of issues or kind management. No? A person voluntarily takes charge of another's abandoned business or property without the owner's knowledge and consent. Okay, let me stop share the screen here for now. Say, for instance, no, Catherine Bernardo has a property, okay? And the neighbor of Catherine Bernardo is Lisa Soberano. Okay, now, Catherine goes to Europe for a vacation. Now, while she is on vacation, there is a storm here in the Philippines. Okay, and there is a typhoon. Now, Lisa, thinking of her neighbor, buys 10 sacks of sand to be placed in front of the door of Catherine's house so that waters will not enter the house. This she does to prevent flooding of the house of Catherine Bernardo. Okay, and then she buys also 2x2 logs, or 2x2 dos por dos, as we call it, no? And place those dos por dos on the windows of the house of Catherine so that the windows will not break. Catherine did not ask her to do all this, but she took it upon herself to assist, to help Catherine, even without the knowledge of Catherine. Now, Catherine comes back and finds her house to be in perfect shape. Now, Lisa shows those receipts to her, amounting to 50,000. Can Catherine just say, "Oh, thank you very much, but why are you showing these receipts to me?" Then Lisa says, "I had incurred these expenses. Please reimburse me." Can Catherine say, "Why should I reimburse you? I did not ask for your assistance," right? Can she do that? The answer is no. She will have to reimburse Lisa. Why? She benefited from the unauthorized management that Lisa did. And so she should reimburse the expenses that Lisa incurred. No, she will be unjustly benefited by the acts of Lisa if she does not reimburse that 50,000. Okay, so that is what is meant by negotiorum gestio. It is a unilateral act, yes, but nonetheless, the one who has engaged in unauthorized management should be reimbursed. Okay, so again, that is what we call negotiorum gestio. What is number two? Number two is solutio indebiti. Okay, so what is an example of solutio indebiti? Assuming, for example, assuming that you need 5,000 for you to use at the end of the bar exams. So you will think, okay, this is the last Sunday. I will rejoice with my friends or with my family. I will get 5,000 from the ATM machine. Okay, I will get that, 5,000 from the ATM machine. So after your last exams, which is very soon, right, you go to the ATM and you try to withdraw 5,000. And lo and behold, what happens is that you get 50,000 instead. So what do? Of course, you jump for joy, right? But do you say, Oh, thank you. Huh? The Lord really works in mysterious ways here. I will keep that money. Is that what you should do? The answer is no. You should return that 45,000 in excess. You know it in your heart that it is incumbent upon you to return said amount of money because that is not yours. That is that of the bank, which was unduly given to you. Okay? You understand? So let me share the screen with you. But before I do class, let me share with you a story. When I was much younger and I was teaching in the University of the Philippines, I was 21 at the time, no? And we did not have cell phones yet. So we used those phone booths, no? Those red phones where we placed coins. Yes. Oh, hindi ko naman naabutan yung 10 cents. No? Ang inabutan ko na yung 25 cents. So we would put 25 cents there. But before I even got to use the phone, I saw a wallet that had, at that time, that had dollars, yen, and pesos, amounting to, at that time, 200,000 pesos. Imagine, no? What a big amount. But did I say, oh, wow, this is for me? The universe is conspiring to give me wealth here or money. No, I did not think of that. No? What did I think of? That money was not mine, and I should return it to the person who owned the same. And as the wallet had that ID, I was able to track her, and return the money to her. Of course, she said thank you, and I was relieved to know that that money was supposed to be spent for her ailing child, sent to her by her husband working abroad. And later on, the child the child recovered from the illness, and of course I was most happy about that. Anyway, going back, that was an example of solution indebiti, where there should be no unjust enrichment. Okay, so I hope that is very clear to you. Let me share the screen again now. Okay, so negosyorum hestio, unauthorized management, and where reimbursement must be made to the gestor for necessary and useful expenses, and there has to be just compensation. Now, insofar as solution indebiti is concerned, okay, something is received when there is no obligation to give. In that instance, for instance, when you use your ATM to get 5,000, the bank did not have any obligation to give you an additional of 45,000, and you had received that. Okay, so payment was unduly made, but the same must be returned. The same must be returned. So that is solution indebiti. Again, by way of a drill, what are the sources of obligation? Number 1, law. Number 2, contracts. Number 3, quasi-contracts. And under quasi-contracts, you have you have negosyorum hestio and solution indebiti. Class, please do not forget. There are questions in the bar on these. On quasi-contract. So it will be a giveaway already if you are able to answer these questions. Okay. Next, are acts or omissions punishable by law as a source of obligation? You know that there is always a civil action or civil liability arising from a crime, say damages in case of death. So let me just stop share these so you can and not be distracted by the slide. Okay. Say, for instance, a man drives, okay, and hits a person, and there is homicide through reckless imprudence. You know, of course, that is a criminal case, but we are not bothered with that since you had already criminal case and this, criminal law exam last time, right? Last Sunday, right? Okay, and we are now reviewing for the civil law bar exam. So what are we looking at here? We are looking at the civil liability arising from that crime. Can there be damages? Yes, no? The family, the aggrieved family of the victim can file damages, can file either an independent civil action, independent from the criminal case, for damages, or the civil aspect of the case can be impliedly instituted in the criminal case. So, two choices, no, for the aggrieved party of the one who had passed away by reason of that homicide through reckless imprudence. Either they instituted impliedly with the criminal case, or they file a separate civil action, independent civil action. Why do we have to know this? No, we just need to know this so that we can identify the quantum of evidence needed. Okay, if the case, civil liability or the civil aspect of the case is concerned, if it is instituted impliedly with the criminal case, then the quantum of evidence required is proof beyond reasonable doubt. Okay, for the civil case. But if it is, what is the aggrieved party, okay, or parties, if they would opt for an independent civil action, then the quantum of evidence required for the civil liability is only preponderance of evidence. Okay, this is not asked very often, no, but just know that there is that civil liability arising from a delict. Say, for instance, there was rape, there was murder, there was homicide, etc., etc. There can be an action for damages. So this action, the civil action of damages, can be instituted, impliedly instituted in the criminal case, or can be filed separately, in which case there is that independent civil action. And the quantum of evidence for the two will be different. Okay, so please keep that in mind. Now, here is where the challenge is. No? On the fifth source of obligation, which is quasi-delict as a source of obligation. Now, how else is quasi-delict called? It is also called negligence, tort, or culpa aquiliana. Okay, a quasi-delict is a fault or negligence which causes damage to another, there being no pre-existing contractual obligation. So, if the question in the bar mentions no pre-existing contractual obligations, then you know that it is referring to quasi-delict as a source of obligations. Now, what are the other names of quasi-delict? You have tort and culpa aquiliana. Culpa meaning negligence. Now, what do I want you to commit to memory here? This one, this visual aid. There is fault or negligence There is that proximate cause, and there is that damage. These negligent acts being the proximate cause that leads to the damage or injury. So please keep these three in mind. Okay, requisites for quasi-delict or tort. There is a fault or negligence, okay, presupposes foreseen harm, damage or injury, and a direct relation between cause and effect. Okay, stop share. For instance, no, if, say for instance, Ian Veneracion. You cannot miss Ian Veneracion, right? Okay, Ian Veneracion goes to a mall. Okay, now, there is that banana peel, no? There inside the mall. Now, earlier that day, the janitor in the mall, no, saw that banana peel, but did not do anything. Now, there was also someone from management or administration of that building, okay, who saw the banana peel, but did not, again, do anything. No? Okay. Now, even a 3-year-old child would know that if somebody steps on that and slips by reason of that banana peel, then the person will be injured, correct? But what did the janitor and that manager do? They did nothing. Despite the fact that they know, okay, that there is that foreseen harm. Correct? They did not do anything. Were they negligent? Yes, they were negligent. Okay. Now, here comes Ian Veneracion in the mall, no? And steps on that banana peel and slips and gets injured. Huh? Imagine ka, pogi-poging lalaki, right? What a handsome guy, no? Being injured because of that. Question, can he file a case against that mall for negligence? The answer is yes. The answer is yes. Although some of you may want to imagine other personalities. No, maybe instead of Ian Veneracion, you may think of who? Huh? Maybe Melanie Marquez, perhaps Carmi Martin, depending on your generation, right? So think of anyone. Think of anyone who can step on that banana peel, slip and fall. Can that person file a case against the mall? And these two persons who were negligent, the answer is yes. Okay, so now let me share the screen again. Why? No, what is the negligent act? In this case, the negligent act was ignoring that banana peel, and instead of throwing it away, no, the janitor and the manager just let it be. Now, that is the proximate cause of Ian's injury. And when you have these three, fault or negligence, which is a proximate cause that leads to damage or injury, then you have a case of negligence. Okay, now, if you still have time, I would encourage you to memorize this. But if not, just remember that visual aid. Okay, what is proximate cause? Proximate cause is that which in its natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury, without which the result would not have occurred. So you break this down into 4 elements or 4 requisites. Number 1, in its natural and continuous sequence. Number 2, unbroken by any efficient intervening cause. Number 3, produces the injury, and number 4, without which the result would not have occurred. So keep that in mind, okay? So what are the other things that I would want you to know? Okay, what about specific, indeterminate, generic, indeterminate things? We're now going to fortuitous event. Are you clear on what we had already discussed? Please, please know those 5 sources of obligations. Trending bar questions on number 1, quasi-contracts, and 2, quasi-delicts or negligence. So please keep that in mind. Then we deal with now classification as to whether the thing is determinate or generic. Now, what is a specific thing? No, the one that you can identify. Okay, the obligation to deliver is extinguished by a fortuitous event, whereas insofar as generic indeterminate thing is concerned, obligation to deliver is not extinguished by a fortuitous event. First, let's look at examples. What are examples of specific thing? Example, 2021 Montero. Okay, Montero Sport, 2021 model Montero Sport, black. Okay, with what? Plate number ABC, 1, 2, 3, 4. You are selling a specific thing, all right? That is specific. What about these South Sea pearls, owned by Professor Mayra Gallardo Batungbacal? Okay, this item is specific. Okay, the earrings are specific. Okay, we can identify. What about generic things? Generic, 10 sacks of rice, for instance. A bicycle. No, it is not specific. It is not determinate. So you have to know whether a thing is specific or generic. Now, why? Why do we have to know that? No, has it ever occurred to you? Bakit ko ba kailangan malaman kung ang isang bagay ay determinate or not? Right? Okay. It is this. When we speak of loss due to a fortuitous event, the question now is the obligation extinguished by a fortuitous event? Remember that a fortuitous event is a defense. It is a defense. Okay, now, if for instance, say, Noemi from Rex, Noemi from Rex, no, is buying, Noemi is buying these specific earrings. And I am to deliver to her these earrings. But a typhoon makes me or made me lose these earrings. Maybe the earrings were flooded away. Question, am I still under obligation to deliver these to Noemi? Can I use fortuitous event as a defense? Sorry, Noemi, there was a typhoon and I lost my earrings due to the typhoon. Am I still under obligation to deliver these earrings to Noemi? The answer is no. Why? These are specific things. And fortuitous event extinguishes my obligation or my liability to deliver these specific things to Noemi. Are we clear? Okay, now, if one of you Say there is a gentleman in this forum who promised his girlfriend that he would give her a ring this Christmas season. Say Mr. Santos, no, if there is a Mr. Santos here, promised his girlfriend that he would give her a ring on December 25, 2022. Okay, now there is an earthquake and a typhoon on December 25, 2022. And the shop lost already the rings there. Question. No? Can Mr. Santos say, sweetheart, I'm sorry, I cannot give you a ring. And I think my obligation is already extinguished by the fact that there was a flood and it took all rings away from the jewelry shop. Is he absolved from his obligation to give a ring to his girlfriend? The answer is no. Why? It was a generic thing. The ring was not specified. So it can be any ring. Now, we go to the principle of a generic thing does not perish. Or in Latin, genus nunquam perit. A generic thing does not perish. And therefore, if you, Mr. Santos, promised your girlfriend, okay, a ring, and the ring has been lost, it's all right. You can find another ring to give her. Your liability is not extinguished. Okay, so please keep in mind that. That is the reason why we have to know whether a thing is generic or not. Whether a thing is specific or generic, or whether a thing is determinate or indeterminate. A fortuitous event extinguishes liability insofar as specific property is concerned. However, if it is a generic thing, then fortuitous event does not extinguish liability, does not extinguish the liability. Okay? Okay. So what are the other things that we will have to know? No? What are the trending things too? Okay. I want you to focus on suspensive and resolutory conditions. What are the other terms for suspensive condition? It is also considered condition precedent or condition antecedent. Okay, what does that mean? Okay, listen. In a suspensive condition, okay, an obligation arises. An obligation arises upon the happening of the suspensive condition. Okay, example. I promised to give you a yacht. Is anyone here interested in a yacht? Yate, right? Okay. And I say, I will give you a yacht if you get 95 or higher in the bar exams tomorrow in civil law. If you get a grade of 95 and above, I give you a yacht. Okay. I promised you that now. Okay. Can you ask from me that, can you ask for a yacht on, say, December 25? Can you say, Mom, you promised me a yacht? And I say, no, my obligation does not arise until the happening of the event. Okay, fast forward to April or May, when the bar exams will be released. The results of the bar exams will be released. And guess what? You got a 98 in civil law. Now, am I under obligation to give you that yacht? And the answer is yes. Why? That suspensive condition has already occurred. Once you have gotten a grade of 95 or beyond, in this case 98 in civil law, then it is incumbent upon me to give you that yacht as promised. You understand? Yes. So please note that, suspensive condition. The obligation arises upon the happening of that event. What is a resolutory condition? What is a resolutory condition? Now, in a resolutory condition class, obligation is terminated or is extinguished at the happening of the event. For you to be able to commit this to memory, resolutory, resolved. So terminated. Example. Your parents tell you, I will support you during your bar review. During your bar review, you do not have to worry. I'll take care of your review. I'll take care of your food. I'll take care of your clothing. I'll take care of your allowance. I'll take care of your rental fee in case you are renting a condominium unit or an apartment while taking the bar exams. Okay? Your review. And your parents says, I'll take care of your review until the last day of your bar exams. So, when does your parent have that obligation? The moment you had started the bar review, then your parents have already taken upon themselves to take care of all your expenses. No? And what is this resolutory condition here? On the last day of the bar, that will be the last day when your parents will support you. And when that last day comes, then their obligation is already extinguished. So that is a difference, class, between a suspensive condition and a resolutory condition. Okay? In a suspensive condition, the obligation arises upon the happening of that condition. Whereas in resolutory condition, okay, the obligation is terminated at the end, upon the happening of that event. Are we clear? Okay. Drill only, So you know what juridical necessity is. You know already the prestations to give, to do, or not to do. You know already the sources of obligations, and there are 5, right? Law, contracts, quasi-contracts, delicts, and quasi-delicts. Then you have learned about fortuitous event, vis-a-vis, determinate, and indeterminate objects, and these things that we have just discussed. Okay, suspensive condition and resolutory condition. Can we still proceed? Okay, clear your minds. I will give you 5 seconds. Okay, close your mind, close your eyes, think of what we had discussed, lock them in. At the count of 5, okay, you will open your eyes for us to start with another topic. At the count of 5, 1, 2, 3, 4, 5. Okay, open your eyes now. All the information has been locked in your minds already. Now we go to another big topic, trending topic, joint and solidary liability. Okay, what is joint liability? What is joint liability? There is joint what is joint liability? Remember? You know this one. You know this. The liability is pro rata or is prorated, right? If, for instance, there are 3 of you, okay, candidate 1, candidate 2, candidate 3. You come to me and you take a loan, okay, and the loan is, say, 9 million. Then we agree that it is joint liability. What happens then? Can I run after bar candidate number 3 for the entire amount? The answer is no. I cannot do that. Why? The liability is joint, prorated, so that each of the 3 bar candidates who owe me should only pay 3 million each. We're clear, right? Bar candidate number 1 pays me 3 million, bar candidate number 2 pays me 3 million, and bar candidate number 3 pays me 3 million. Now, that is joint liability. Okay, what is solidary liability? If, say for instance, in this case, there were 5 people who borrowed money from me. Say I did not really know the 4, and I just only knew, say, celebrity 1, 2, 3, 4, 5. I did not know the 4 celebrities really in person, but only knew 1. Example, so you will be able to commit to memory. Say for instance, who are these? Ogie, Regine, Martin, Gary, and Lani Misalucha. Okay, those 5 people came to me and asked for 100 million. Okay, I tell Ogie, Ogie, I do not know your friends, I just see them on TV and in shows, but I do not know them personally. But if you vouch for them, okay. So I'm lending you 100 million. And the liability is solidary liability. Okay, so there was an agreement that there would be solidary liability. These celebrities owed me 100 million. Now, can I ask, assuming Martin absconds, Lani goes to Las Vegas, I cannot find them anymore, and only Regine and Ogie stay in the Philippines. Can I go to Ogie and say, Ogie, you have to pay me now, per our agreement. You now pay me 100 million. You have all defaulted, pero nakita ko si Ogie. Okay, can I ask Ogie for the entire amount, subject to reimbursement, by those other 4? The answer is yes. Okay, do not use this word in the bar exams, but only for your conceptual framework. All for one, one for all. Okay, so I can run after Ogie for the entire 100 million. Now, it is up to Ogie if he wants to be reimbursed by all these others. Can he get 20 million from Martin? Yes. 20 million from Lani Misalucha? Yes. 20 million from Regine? Yes. Okay, 20 million from Gary V? Yes. Okay, what about the other 20? That is his share. Okay, so please note the difference between joint and solidary. Now, in solidary liability, can Ogie ask for reimbursement for those 80 million? The answer is yes. Now, question, what if the agreement does not say whether it is joint or solidary? The agreement does not say. Then we presume that the obligation is what? That the obligation is only joint. Why? It is less burdensome. Right? Imagine solidarity obligation when one debtor should pay the entire amount, although there is a reimbursement. That is burdensome, right? You would rather just pay your proportionate share. And that is why we have the presumption of joint liability. So please keep that in mind. Ito ang mga trending questions. Suspensive condition, resolutory condition, joint liability, solidarity liability. Okay, are we clear? Okay, next. Another favorite would be, okay, would be this one that have been, okay, joint and, before we leave this, by the way, I want you to know the different names because there was a question in the bar exams before when it used either Latin or Spanish. No? And if you do not know these names, you will get lost. Okay, for joint liability, what are the other terms for joint? It is called mancomunada. It may also be called mancomunada. Mancomunada simple, of course, pro rata, we know that. Proportionate, we know that. But please keep in mind mancomunada or mancomunada simple. And then we can also use this. We promise to pay with 2 or more signatures. Okay, now, insofar as solidarity obligation is concerned, of course, we know joint and several. Please, 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 do not mistake joint and several for joint. Iba yun, ha? Look at this column. Joint is on the left side, solidarity is on the right side. But another term for solidarity is joint and several. So if you say they have a joint and several obligation or they have joint and several liability, then you know that that stands for solidarity. Or if we say in solidum, individually and collectively, mancomunada solidaria, or juntos y separadamente, or I promise to pay with 2 or more signatures, then that is solidarity. Okay, please keep that in mind. Okay, and we are big also on extinguishment of obligations. What are the forms of extinguishment of obligations? We have performance, loss of the thing due, condonation, compensation, merger, novation. Okay, please look at this now. Please come now, Papa Coco Martin Love. Oh, what does that mean? Okay, I taught obligations and contracts before, and I had an activity for the class. So I said, I will give the biggest Toblerone to someone who can make an effective mnemonic device for extinguishment of obligations. No? And there was this fellow, he was a guy, he was a man, he was a male, who came up with this. Please come now, Papa Coco Martin Love, as a mnemonic device for extinguishment of obligations. Please come now, Papa Coco Martin Love. And at the time, I did not know who Coco Martin was. But when I learned, this has become my mantra already for extinguishment of obligations. Please come now, Papa Coco Martin Love. P for performance, please. P for performance. Please come. C for condonation. Please come now. N for novation. Please come now. Papa, another P. Payment. Please come now, Papa. Coco, another C, right? Compensation. Please come now, Papa Coco. M, merger. Now, please come now, Papa Coco Martin. M for merger, love. Please come now, Papa Coco Martin, love. Loss of the kingdom. Di ba? Ang galing niya. He really deserved that biggest Toblerone. And he is now a faculty member of an academic institution. No? I knew he was going, he was a very diligent, conscientious student, and I knew he would excel. And he is now excelling. He has obtained several master's degrees in different universities abroad. So do not forget that. Please come now, Papa Coco Martin, love. So no, I'm sure you know those, but I am just providing you now with mnemonic device. Okay? I hope that you have memorized that. Okay. Miss Cristel?
Yes po, attorney.
Yes. Do we get to have a health break? 5-minute health break?
It's okay if you want po.
Sige, only 3 minutes, just so they could grab their bottles of water. We can pause the recording and then we can resume after 3 minutes. Thank you very much.
Thank you, attorney.
Okay, everyone, just 3 minutes. Thank you.
Stressed out? Wishing for new ways to learn and master codal provisions? Codify makes it easy. With just a few taps, you can customize and select the tracks to memorize or study further. With Codify's Playlist Manager, choose from the subjects and create your own playlist. Imagine your own law track. Experience studying the law anytime, anywhere. Fortify learning with Codify. Meet your new learning buddy. Download Codify now. Achieve your learning goals, one track at a time. Listen and learn with Codify. Get the app today. Your first 7 days are on us.
Ako si Romel, Proud Print Production Manager.
Ako si Giselle, proud pre-press artist.
Ako si Dom, proud ako na production supervisor.
Ako si Ann, proud editor.
Ako si Jonah, proud researcher.
Ako si Chris, proud author.
Ako si Roxanne, proud artist.
Ako si Nelly, proud sales assistant.
Proud ako na nagagamit ko ang aking talento para matulungan ang isang estudyante, guro o magulang na magkaroon ng imahen ng isang aralin na kanilang gusto o kailangan matutunan.
Proud ako kasi sa umpisa pa lang ng book development kasama na ako. Working with the authors, so sa journey ng libro hanggang sa magamit na ito ng mga learners. Para makatulong to make them whole and responsible Filipinos. It's a good feeling.
Maaaring sa iba ay tagasakay ka lang naman ng papel sa makina. Ngunit, ang kada papel na yon ay siyang bumubuo ng isang libro na nakatutulong sa isang bata o sa isang tao upang matuto at umunlad. Proud ako na maging bahagi ng prosesong ito.
Proud ako na yung pinag-aralan ko, yung pinagsikapan ko, yung pinuhunan ko ng bawat oras, pagod at puyat, ngayon buo na, ngayon isa ng libro. I am full of hope na ang bawat makabasa nito, matuto, makinabang at makibahagi.
Teacher ang nanay ko. Proud akong gumising sa bawat araw na alam kong may ginagawa ko ang makakatulong sa kanya sa araw-araw niyang pagtatrabaho.
Proud ako maging print production group manager dito sa Rex Printing dahil ang ginagawa naming libro ay nagbibigay ng kaalaman sa mga kabataan. At isa pa, siyempre nagbibigay financial support sa aking pamilya. Kaya proud ako.
Yung anak ko, nakita ko na hawak niya yung isang libro na inimprenta natin. Nakwento daw niya sa mga kaklase niya na dito ako nagtatrabaho sa Rex. Nabanggit din niya yung mga pagbabasa at pag-e-edit na ginagawa ko sa mga produkto natin para masiguradong maganda at maayos ang kalalabasan ng mga produkto. Gabi na nga daw ako umuwi kung minsan para lang matapos yung libro. Para sa pamilya, para sa bata, konting sakripisyo, kayang-kaya.
Nung nag-aaral ako, marami rin kaming libro. Lalo na yung nag-aaral ako sa law. Never akong gumamit ng photocopy or illegal downloads. Gusto ko kasi yung pakiramdam na may hinahawakan ka ng totoong libro. And those books helped me become who I am today. So proud ako kasi alam kong may isang tao rin ako matulungan sa pagsusulat nito.
Proud ako kasi bawat customer na nakakaharap po namin dito sa branch, laging may kwento. Ang anak ko, naku, ayun, pumasa na sa kanyang exam. Salamat sa inyong libro. O di kaya may lalapit na, buti na lang, may kopya kami ng ganitong title. Hulog kami ng langit. Ang makita ng ganitong mga ngiti sa mga customers sa tuwing nakakuha sila ng kopya ng title ng libro, nakakagaan din ng loob. Kasi parang naging parte na rin tayo ng buhay nila at ng journey nila.
Ako si Tony Morano, proud customer of Rex. Sa lahat ng nagbigay ng oras, atensyon, expertise, sa lahat na rin na nagpagod at nagpuyat para sa mga libro ngayon ay lifeline ko. Proud book owner ako at proud ako sa inyo.
It takes a whole community to raise a whole child, and a whole community to create learning solutions to help every learner. Sa lahat ng edukampiyon sa likod ng bawat papel ng ating mga libro, proud kami sa inyo.
Okay, we are back. I hope everybody was able to take advantage of the short break. We would like to welcome back Atty. Batungbacal to continue her lecture on civil law.
Okay, thank you very much, Reg. So we resume. No? Let me share the screen with you now. Okay, and as I have said, please just remember this. Please come now, Papa Coco Martin Love, for your mnemonic device for extinguishment of obligations. Okay, so we go now to contracts, right? I just want to be very brief here. I know that we have only 30 more minutes left. Okay, so let me just go to the salient points of contracts. So a contract, as you know, is a meeting of the minds between two persons whereby one binds himself with respect to another to give something or to render some service. So it is the meeting of the minds. Okay, so meeting of the minds, as I always use this example in discussing contracts. Have you ever said to your partner, your girlfriend, to someone you are romantically attached to, for instance, have you ever said, ano na ba tayo? What are we? Okay. If you had asked that question, there is no contract, there is no agreement because you do not know the status of your relationship. And if there is no meeting of the contracts, meeting of the minds, there is no contract, there are no rights, and there are no obligations. Or there may be rights, but no obligations. Oh, so get out of that relationship already. It is not the meeting of the hands, or it is not the meeting of the hearts. It is the meeting of the minds in contract. Okay? What are the three elements of contract? What are the three requisites of a contract? And you know this, right? Consent, object, and consideration. Now, when questions involving these may either be on consent or on consideration. Now, let's go to consideration, for instance. No? If Miss Regine, for instance, Suarez of Pals, would want to buy the beach resort of Miss Noemi here for 200 million, no? I mean, Miss Regina would want to buy the beach resort. Now, Miss Noemi is selling it for 200 million. But for Miss Regina, that amount is unconscionable. So, she negotiates with Miss Noemi. Miss Noemi, Miss Regina says, I'm really interested to buy your beach resort. But 200 million is too much. So they've been negotiating all day. All day. No? Hindi ko naman kaya yung 100 million lang. Sabi ni Miss Noemi, lugi naman ako dyan. And I have taken care of this resort for years already. And I have incurred expenses in having improvements in this property. Regina says, I cannot afford the 200 million. Why not this amount? And so they were going back and forth until they got tired. The following week, Miss Regina goes back to Miss Noemi only to learn that Noemi has already sold it to someone. No, can Regina say, but we have been discussing this for a day already. And I've given you 1 week already to think about it. You should have sold it to me. Now, was Miss Noemi under obligation to sell it to Regina? Was there a meeting of the minds? And you know that the answer is no. Why? They did not agree on the consideration. They did not agree on the price. Hence, Regina cannot file a case against Noemi, or even if she does, the case will not prosper. Why? There is no contract, there are no obligations, and there are no rights. Are we clear? Okay, so I know that you get that. Let's now go to other matters about contracts. So know that in contracts, there was also a question as to these stages of contract. This has been asked before. Preparation characterized by negotiation. So there is no perfection of contract yet when people are, or the parties are still trying to negotiate, as in the example that I had given you. Now, there is perfection of the contract when there is a definite agreement as to subject matter and cause. Sale of, say, that beach resort for 150 million, and they have agreed, then there is perfected contract. Now, another stage is a consummation where obligations have already been performed or contract is already executed. Okay, so please keep that in mind. Now, this has been asked also. Basic principles: consensuality, mutuality, relativity, autonomy. I think in the past 20 years, this has been asked about 2 or 3 times. Okay, so it may be ripe now. So what are these? What are the common, what are the basic principles? Number one, consensuality, where contract is perfected by mere consent. Mutuality, where parties are bound by the terms of the contract and their consequences. Of course, the parties are bound to observe and to comply with the terms of the contract, and you call that mutuality. Next is relativity, where the contract binds only the parties, heirs, and their assigns. Okay? It binds only parties, heirs, and their assigns. And number 4 is autonomy. As we had discussed earlier, parties are free to make terms and conditions, or there is freedom to stipulate. Parties are free to stipulate terms and conditions of the contract. So again, may I bring your attention to these basic principles? Of course, essential requisites, consent, object, and consideration. Now, remember this, COC, consent, object, consideration for any contract. Now, insofar as real contracts are concerned, the deposit, when you deposit something, say in a hotel, you want it to be placed in their vault, or you are in an inn and you want to deposit something for safekeeping, or where there is pledge. What is pledge? In Filipino, that means sangla, pag nagsasangla ka. Or when there is comodatum, meaning that you are lending someone a non-consumable in credit transactions. Okay, there is always delivery here. COCD, consent, object, consideration, and delivery insofar as real contracts is concerned. Now, this is logical. How can you deposit something if you do not deliver that item for deposit, right? So please keep that in mind. So consent, I know that you know these already, and object. So, okay. So what do I want you to look at here? Okay, know that a contract can either be written or oral. So hindi ibig sabihin na hindi nakasulat, wala nang usapan, wala nang agreement. No, there is such a thing as oral contract. But you know also that there needs to be a form for contracts under the statute of limitations. Just be ready. Okay, now, what else? Defective contracts, voidable, unenforceable, and void contracts. Again, insofar as contracts is concerned, most of the questions fall within the purview of the COC, the perfection of the contract, meeting of the minds, and the COC. Consent, object, and consideration. Then, also defective contracts. And of all these contracts, there have been a lot of questions on rescissible contracts. What are these? Valid until rescinded with extrinsic defect of consisting of economic damage or lesion. There are two grounds for rescissible contracts. One is with respect to economic damage or lesion pertaining to the sale of the property of the ward, right? Or the absentee, correct? And another provision of the law is with respect to breach of contract. Pwede bang mapawalang visa ang kontrata? Yes, pwede. If there is a breach of contract. So of all these four, we're big on this. Rescissible contract. So if you have time, you can take a look at this. Remember that the contract is valid until rescinded. Keep that in mind. And what is the ground to rescind? Economic lesion or breach of contract. Now, insofar as voidable contracts are concerned, voidable, it is valid, voidable contract, it is valid until annulled. What is vitiated contract? Number, voidable contract. These cannot be sued upon. What are examples of unenforceable contract? If say my agent, who is my agent, as Albert, if I ask Albert to sell my property for 100 million and he sold it for 75 million, is that binding? Can it be sued upon? The answer is no. Why? It was an unauthorized contract. I did not give him authority to sell my property for 75 million only. But can I ratify it later? Can I ratify it later? And say, okay, 75 million is 75 million. O sige na nga. Okay, let's do this. Let's sell this property for 75 million. Pwede? Pwede. Why? An enforceable contract can be ratified. Okay? So, what about void contracts? These cannot produce any effect because it is invalid. It is void from the beginning and thus cannot be ratified. Remember, a void contract cannot be ratified. Again, defective contracts, rescissible, voidable, unenforceable, void. Rescissible, what do you think of? You think of economic lesion or breach of contract. Voidable contracts, question of vitiated consent. Unenforceable, no authority. And void, invalid, cannot be ratified. Okay, are we good? Are we good? Okay, good. Can we now go to another topic? Just close your eyes. I'll just ask you to close your eyes so that you can compartmentalize what you have just learned. We looked at the elements of contract, okay? Consent, object, and consideration. We talked about meeting of the minds, perfection of the contract, stages of a contract, okay? And we dealt with, albeit briefly, the defective contracts, meaning rescissible, namely rescissible contracts, voidable contracts, unenforceable contracts, and void contracts. At the count of 5, you will open your eyes and we will start with wills and succession. We will have 30 minutes for this and we will do the very best we can to take on some topics in wills and succession. At the count of 5, 1, 2, 3, 4, 5. Okay, open your eyes now as we do wills and succession. Okay, oops. Wrong one. Okay, wills. Okay, we have a lot of, there are a lot of topics in wills and succession, but I will just choose. Number 1, Article 774, succession is a mode of acquisition by virtue of which the property rights and obligations to the extent of the value of an inheritance of a person are transmitted through his death to another or others, either by will or by operation of the law. So there are 4 things to remember here. Number 1, it is a mode of acquisition, right? If you inherit, say, a vast tract of land, that becomes yours at the moment of the death of the decedent. Okay, property rights and obligations are transferred either by will or by operation of the law, and it is imperative that there is death of the decedent. Okay, the making of a will is a statutory right, class. Huh? This is not an inalienable right. This right was given to us by law. In fact, women did not have the right to make a will prior to 1950. But in 1950, nagkaroon na tayo ng batas para makagawa ang mga kababaihan ng testamento. So this is a statutory right. When we say that the testator has a right to control to a certain degree the disposition of his estate or after his death, that means that he can only dispose of the free portion. He can only dispose of the free portion and not the legitimate. Okay. Now, when we say testate succession, when we refer to testate succession, immediately think of a pie, the net estate, divided into two. One part, 50%, refers to the legitimate and 50% to the free portion. Okay, I'll be the casualty here. I'll be the testator. No, that's why when we say testate succession, we think of a pie cut into half, where there is a 50% is a legitimate and 50% is a free portion. Now, I only have one spouse and one child. And so they are my compulsory heirs, right? So they go to that part where there is a legitimate reserved for them. I cannot touch that. I cannot impair that. So if I leave an estate of 100 million, 50% goes to the legitimate, 50% goes to the free portion. So yung 50 million is already reserved for my compulsory heirs, meaning for my husband and my child. Okay, I cannot impair that. The 50 million is just for them. Now, what about the other 50 million? The other 50 million I can give away. I am free to dispose that. And I can institute voluntary heirs. Now, voluntary heirs can be devices or can be legatees, and you know that. Now, can I give 10 million out of that 100 million to, say, the University of the Philippines, my alma mater? The answer is yes. Can I give another 10 million for Tahanang Walang Hagdan as an advocacy of mine, no, where I would want to give help to those who are differently abled? The answer is yes. Can I give 10 million, for instance, to as scholarship to students taking up law who are very diligent? Pwede ba yun? Can I give to a certain foundation that gives scholarships to indigent law students? The answer is yes. Okay, and then the other 10 million, for instance, can I donate it to kapisanan ng mga broadcaster ng Pilipinas? Yes. Pwede, why not? Right? What about the last 10 million? Can I give to my compulsory heirs in addition to their legitimate? The answer is yes. Right? Okay. So, think of a pie when you think of testate succession, where you can institute. Okay? Now, what happens if there is intestate succession? When there is intestate succession, there are no voluntary heirs. My entire 100 million goes to my compulsory heirs. Please keep that in mind. I cannot impair their legitimate. Okay? Now, what about mixed succession? Is there such a thing as mixed succession? The answer is yes. How? Paano kung nakalimutan ko yung mga pera ko sa bangko? Who will get those? Okay. If I have a will, then the will, as I had mentioned earlier, will dispose of my 100 million estate will be divided accordingly. As I had stated, legitimate goes to my compulsory heirs, and the 50 million goes to my legatees and to my legatees. since I did not give any real property, just to personal property. So the personal property goes to the legatee. So that is testate succession, right? Paano nagkaroon ng intestate? Kasi mixed there, right? The money that I have in the bank will be given to my compulsory heirs, not voluntary heirs. No, remember? Since it is not covered by my will, then it goes to intestate succession, meaning that it just goes to my compulsory heirs. Okay? Oh, what is another situation where there can be mixed succession? No, I've made a will, right? I've made a will already, and then I have acquired, say, 10 helicopters. After I made that will, kanino pupunta yung 10 helicopters? Will the 10 helicopters goes to UP? No. To Tahanang Walang Hagdan? No. To the foundation? No. To the broadcaster ng Pilipinas? No. The 10 helicopters will go to my compulsory heirs. It will be dealt with. It will be considered part of intestate succession. So testate and intestate is equal to what? Mixed succession. Okay, I hope that is clear. Okay, so what is one thing too that I would want you to know in wills and succession? Remember that ownership, successional rights open at the moment of death of the decedent. Successional rights open at the moment of death. If there is a will by the testator or of the testator, if there is no will by the decedent, it is at the moment of death. So for instance, say, say, Garcia, what is his name? This actor, Ernie Garcia. What is his name? Ernie Garcia. Okay, so say there is that Garcia, an actor, left behind a spouse and a child. Okay, say he passed away at 8 in the morning today. Can the child now sell his share after 4 hours? Well, a little unfathomable, no? Because in our culture, we really grieve, right? After the death of a loved one. But even that assuming, say the child sells his share, pwede ba? Upon the death or 4 hours after the death of his or her father? The answer is yes. Why? Ownership has been transferred to the heirs at the moment of death of the decedent. So the moment he took his last breath, ownership has been passed on to his heirs. Okay? And the heir can sell that property. Now, this has been asked in the bar several times already. Will the heir have to wait for a title to that land? Or to that property? The answer is no. A title is a mere proof of ownership. No? But the point here is that ownership has already been transferred. Rights, obligations, property have already been transferred to the heir at the moment of death. So there need not be any partition, decree, etc. Guguluhin kayo niyan. The question may confuse you, but stand your ground. You know that property rights and obligations are transmitted upon the death. Upon the death. Okay. Now, what if the child sells the entire property? Is the sale valid? The answer is no. The answer is yes, it is valid, but only insofar as his or her share is concerned. The child cannot sell the share of the remaining parent or the surviving parent. Hindi kanya yun eh. He is only or she is only a co-heir. So that the sale is valid, yes, but only up to his or her share. Class. There have been several questions on that already. So please keep that in mind. Another scenario. Buhay pa ang parents. O buhay ang tatay and nanay. Can an only child say to his or her best friend, you buy this property. After all, I am inheriting it. I am the only child. I'm selling it to you for a discount. That beach resort that you've always wanted, instead of 200 million, I will just give it to you. I will just sell it to you for 100 million. Pwede ba yon? The answer is no. Why? The child only has an inchoate right, an incomplete right, and therefore cannot sell what he does not have. Remember the Latin maxim, nemo dat quod non habet, right? You cannot sell what you do not have. You cannot transfer. You cannot give what you do not have. Para yung love. If you do not have love in yourself, you cannot share it, right? Okay, so remember, ownership. You can only transfer what you have. So a child here cannot sell a future inheritance, a property constituting future inheritance. Why? He is not the owner of that property yet. Okay, remember, for successional rights to kick in or to be applicable, someone will have to pass away. That's a sad part. No, in wills and succession, there is always death. Okay, so please keep that in mind. That's one. Another thing that I would want to share with you is about joint wills. Class, this is big. They always ask about joint wills. So what are joint wills? Joint wills, as you know, are not allowed. The general rule is that joint wills are not allowed. And there is only one exception. And it refers to foreigners executing a will abroad where it is valid there. That is the only time a joint will is allowed in the Philippines. Okay? So, let me give you 4 scenarios here para lahat na ng tanong covered natin. Okay, Kathniel, for instance, Catherine and Daniel Padilla. They go to Boracay. Both Filipinos, they go to Boracay. Very romantic place for them. And so, Daniel says, Catherine, as a manifestation of my love for you, let's make a joint will together here. Question, is that joint will allowed? The answer is no, it is not allowed. Joint wills made by Filipinos here in the Philippines, not allowed by law. It is prohibited. Okay, next. What about Catherine Bernardo and Daniel Padilla? They go to Spain, and they fall in love with the place. And Catherine says, mi amor, me gustaría obtener, me gustaría hacer un testamento final, contigo. I want to make a joint will with you. Is that joint will valid? Filipinos executing it abroad? The answer again is no. So what is the rule? If the joint will concerns Filipinos, whether Filipinos do it here in the Philippines or abroad, X, invalid. Okay, next scenario, 3rd scenario. Angelina Jolie and Brad Pitt come to the Philippines, Mr. and Mrs. Smith. They go to Palawan, fall in love with the place. And Angelina, you know, she loves children, international children, right? So she falls in love with our children in Palawan. And then she tells Brad Pitt and encourages him to make a joint will in Palawan. Is a joint will valid or not? The answer is, it is invalid by reason of public policy. Okay, Now, Angelina Jolie and Brad Pitt, they go to Italy. They love it there. They went to the Colosseum. They went to what palaces, and they just felt like making a joint will there, where it is valid. Will it be allowed probate here in the Philippines? The answer is yes, because that is the only exception to the rule. O class, we have covered already 4 situations. Hindi na kayo pwedeng magkamali dyan. I know that you get this very well. Okay, so joint wills. We have 2 more minutes. What else? Okay. Please do not forget your Article 805 and your Article 18. 805 refers to requisites of a notarial will. Number 1, it has to be in writing. Hindi pwedeng salita lang. Okay? It has to be in writing. Number 2, it should be in a language known to the testator. If I know only 4 phrases, if I know only je t'aime, if I only know je m'appelle Angie, if I only know comment allez-vous, if I only know je ne sais pas français, can I write in French? The answer is no, because that language is not known to me. I just know some phrases, no? So there is no compliance with that requirement. Number 3, it will have to be subscribed by the testator. Subscribe, pinirmahan ng testator. And if he cannot do this, he can ask someone to put his name on his behalf, provided that this person writes his name in his presence and by his express direction. Express direction. Number 4, witnesses should attest to this, must attest to this will in the presence of the testator and of each other. Number 5, marginal notes. Number 6, correlatively numbered in letters. No, page 1, PAGEONE. Page 2, PAGETWO. Paano kung hindi spelled? No, but using numbers, number 1, number 2, number 3. Is there compliance? Yes, there is substantial compliance. Number 7, 7th requirement is the attestation clause. Class, dito maraming tanong on the attestation clause. The attestation clause is the work of the witnesses, not of the testator. So there is no need for the testator to sign this. What should be included in the attestation clause? Number 1, the number of pages. Why? We do not want somebody to insert a page there and claim, no? O ito, binigyan ako ni Atty. Gallardo Batungbacal ng property, simply because there is no pagination, right? So the attestation clause will prove that there are only 10 pages. So the witnesses say, we, Regina Suarez, Rex Noemi, and Albert Martinez, okay, are the witnesses to the execution of the will of Professor Myra Gallardo Batungbacal. And we state the following. We attest to the truth of the following. Number 1, the will has 10 pages, including this attestation clause and the acknowledgement. Number 2, the testator signed in the presence of the witnesses. So number 2 refers to the testator. And you will have to say that the testator signed in the presence of the witnesses. And number 3, witnesses signed in the presence of 1, the testator, and 2 of each other. Please keep that in mind. There have been questions on these already, and you do not want to miss these. And of course, their names and their signatures should appear under the signature. Now, there are a lot of questions in wills in succession, either on joint wills and on the requirement that the testator and the witnesses are in the presence of each other. What do you mean by that? Assuming that I have 3 witnesses, Mr. A, B, and C, and I am the testator. We are in one room. A plays video games. B reads Harry Potter. Okay, and C, probably paints, and did not see me sign. Is the testator in the presence of the witnesses, and are the witnesses in the presence of the testator and of each other? The answer there is yes. Why? There was no physical obstruction. And number 2, had the person wanted to see, well, if there was a possibility of seeing, he could have seen the person write or affix a signature. Then there is that compliance with that requirement. But say, for instance, the 3rd witness keeps going out of the room. No, probably one of the witnesses has morning sickness and goes in and out of the room. Is there compliance with the requirement of being in the presence of? The answer is no, because there is physical obstruction. Okay, so please keep those things in mind. And insofar as holographic will is concerned, it should be completely handwritten, dated, and signed. Pwede bang gamitin ang foot, the foot or the mouth to sign if the person does not have hands? The answer is yes. There are Supreme Court cases on this already. No? Why? You may ask, but it says, the law says it should be handwritten. Remember that the spirit of the law intends to establish genuineness and authenticity. So if we sign through using our foot and using our mouth, we still comply with it, with that requirement. What about with the ear? Pwede? Well, there is no jurisprudence yet, but for the mouth, yes. For the foot, yes also. Okay, I wish to share more with you, but our time is already up. I hope that you have learned from this brief lecture, only a 2-hour lecture. Please note that I wish you all the best, and I shall be praying for you when you take your bar exams in civil law tomorrow. God bless you all, and keep believing. Okay, thank you very much.
Thank you so much, Atty. Batungbacal, for sharing with us your extensive knowledge on civil law. Sobrang natandaan ko yung kay Coco Martin. And also, thank you to our partners, Rex Bookstore and Next Educampion, for making this event possible. We would like to remind everybody that our frequently asked topics on the Bar Subject Lecture series is still ongoing. You also have legal ethics and remedial law to tackle. So make sure to follow the Pals and Rex Bookstore Facebook pages for the roster of speakers and for further updates. We hope that
thank you very much, and good luck. Thank you, Reggie, and salamat. Thank you. I have to go now. I have another.
Okay, thank you, Attorney.
Okay, good luck, everyone.
Good luck, everybody.
Have faith. You can nail this. You can do this. Goodbye.
Goodbye, Attorney. So we hope that everybody tuned into our stream learned a lot from this morning/afternoon lecture. Thank you, everybody. Have a great afternoon, and we'll see you all on the next one.